no notice served.
Yes.
What is the prejudice you suffer if the admission is now heard?
No, I'll tell your lordship why. I'll tell your lordship. Today the issue is this, not I'm on bail. I'm on bail now. I've been on bail since the last 6 odd months. The issue is this. Assuming we go, but the issue is they may have a remedy in bail in terms of supervening circumstances, etc., whatever, or the illegality of the bail order. But if the revision is allowed to be maintained, then in effect the remand is under challenge. That will affect my liberty. So today my concern is this: if they have a remedy against the release on bail, that remedy is a distinct remedy. By revision, they are going back to the root, which is the remand. And today the issue will be that there is a direct consequence on the liberty that I already have. Just a minute. Just a minute. But in essence, the issue of bail will now be adjudicated in the revision, which, with respect, I believe cannot be done.
Sorry, the dismissal.
But would your lordship consider this, no? Would your lordship consider, not there is, and may I just place Usman Bhai for a moment? And your lordship may just examine that one? Because not the...
Go back. I mean, you will not be prejudiced. Anyway, you have got this month's deducted.
But then may I just say this? May I just say, Lord, please see where the High Court has left me.
You want any observation to that?
But,
we can...
I'll please see para 24 for a moment.
Yes, sir. Okay. 24.
Yes, now not the issue is this. Para 24, is your lordship have that? The High Court says pending the revision. My respectful submission is not, because there is an issue. May I make two submissions?
Yes.
Allow me to go back and I will argue this issue on the revision, not leave that issue also open for me if I have to argue before the revision court. That's one prayer I'm making. And second prayer, Lord, in the event the revision is against me, Lord, I should have some time to go to the High Court. There's two issues.
That's fair. That's fair. In the event the revision goes against it, you will grant him some time.
And I should be allowed to argue the maintainability of revision before the
Law takes care of it. No further direction may be necessary. Law takes care of it.
You can make this request to the revision.
Lord, I will not, revisional court will not be able to grant that, not because the moment the revision court decides the matter, that jurisdiction is over. It's not only in Bombay and Gujarat and where the High Court under 482 gives extension orders, the power is over. And not, let me argue all points, including maintainability before that court.
Maintainability is concluded.
No, I'm asking the court.
We have heard counsel for the parties and are of the opinion that no interference is called for. All contentions of the parties before the revisional court are kept open. In the event of an adverse order, the petitioner shall be protected for a period of 1 week.
But 2 weeks, make it, because sometimes there are vacations, not vacations, etc.
Not that I'm not. You're 142, your jurisdiction, I will not say anything about that.
But he's in Chittor, not the High Court is in Amaravati, not very well.
My Lord should consider, is that necessary in a case like this?
What is necessary now? He has been at large for 6 months.
That's why he fully heard in the revision. Now, whenever revisional order goes against him, remedies are available to him under law. He need not give anything more than that. What's contemplated?
2 weeks, your lordship consider abroad.
No.
Because this transport is in Chittor, Amaravati, not the best connected places. I know, Lord, I end up going there often. I end up going to Amaravati, is not the best connected, Lord.
All right.
2 weeks.
1 week.
I'm grateful, Lord. Deeply obliged for the kind hearing. I've taken a lot of time.
My lords, may I mention item 38? My lords, I'm seeking a short adjournment. I'm not feeling well, my lords. Next item, my lords. The report also hasn't come from the High Court, my lords.
Counsel is Miss Nikra is on the screen.
Who is for the respondent?
I appear for the statement 38.
She is not well.
Yes, and record is also not yet received.
What has not been received? Yes, after 6.
If you will.
Yeah.
Your Lordship's leave, may I mention item 47?
Yes.
Your Lordship, being led by the attorney, Your Lordship, in this matter.
But I think what about the respondent?
And the state is generally I'll mention after lunch.
This is not only the state, the complainant is also.
Complainant, Your Lordships, we have now moved an impediment application. They are not there. There was no complainant, it was so moved.
We'll see after.
सिम खराब है इसलिए उसका नेट नहीं चल रहा है इसका सिम इसको चेंज करना है दूसरे दूसरे से हॉटस्पॉट कनेक्ट करना इसी को तो है ये सिम तब तक मैं लाइट ऐसे थोड़ी कि नहीं है रहेगा अच्छा अभी तब तक कैसे रहेगा वही तो पूछ रहा है यहाँ पे भी बैकग्राउंड इमेज यहाँ डालना होगा फ्रंट कैमरा ऑन करके फ्रंट कैमरा करके बोल देगा लंच ब्रेक हुआ है सर.
Item 39. With your lordship permission, may I mention item 23 also. Your Honor, disposes of the on the premises that if a partnership firm is even if not a equal partners can be prosecuted.
We have only said like the direction.
The direction, but my lord, but your lordship has held that the prosecution will go on against the partners. But my lord, I have a judgment. I just want to bring to your notice.
Made the order now. Let it go on. You can show it to the concerned court now. But you use this before the concerned.
But it's quite clear, my lord. It says that. But that's why I just want to bring to your honors.
No, sir.
Item 39.
Lordship, I am appearing for respondent. Your Lordship, please, if you may accommodate us, since there have been bereavement in the Arjun Council's family.
See, who is the counsel?
Sir, I am.
Samavijay Singh.
For the statement, I am the petitioner. Notice has been served on the state council as well as on the complaint, defector complaint. Defector complaint has made appearance. Meanwhile, we are ready with the 20.
Who is the complainant?
Complaint has not appeared today.
So, when is he likely to return the counsel?
Your Lordship, 1 week time period.
But we have that, Lordship kindly record that we have DD. Lordship kindly record that we have DD Miller to be given to them. That is a balance amount for 20 lakhs. DD we have Miller. One thing. Secondly, Miller.
You have it with you. You keep it.
Let's.
You keep the DD.
Yes.
We'll keep
Miller.
it.
Miller, only one small submission. Now the matter is before the Honorable Magistrate. Miller, he has recorded last time. It is an admitted fact that the proceedings of this case have not been stayed by the Honorable Supreme Court of India. Then Miller, he says, it is clarified.
What is the date of the order? What is the date of the order?
So this date of the order 10/2/2023. He says, Miller, it is clarified to the Honorable Counsel for the accused that in case proceeding before this court are not stayed till next date, this court shall proceed to hear argument.
Show the order. Show the order.
We will find it. We will find it already. Anyway.
But the counsel is not here. Where is the complainant's counsel?
It is not here.
Services completed.
We will find it out. It is expected that
Presented before the trial court, no?
Yes, no.
Immediately after vexation, someday. In the meanwhile, proceedings, the trial court shall not go ahead with the pending proceedings. Complaint number, what is the FIR number?
The CC number.
CC number.
CC number. Sorry, but I will give the number. CC number.
Rising CC number 78, rising of the
CC number 78 of 2014.
2014. Say,
rising of the
CC number. First, a light should be when the counsel appearing on request for adjournment is made on behalf of counsel for the state. Submitted that he has suffered a bereavement. Next is stay shall not be continued in the next state of hearing. List on so on.
Grateful. Item 43.
But the office report indicates that NCB has left without instructions.
I am appearing for state. Respond number 2 is LCB.
What's your instruction in this matter?
NCB is the main party. They have made an application for.
No, state is actually not a necessary party because
You want your passport back for a foreign travel?
foreign interview.
What foreign travel?
I had indicated at the point in time when I had asked for, requested for it, there was a meeting for which I was expected to go. But
It's long over now.
it's not over.
What is the state? Sorry, what is the state of the trial now?
Not even charges have been framed.
I'll have to seek instructions. Lordship may issue fresh notice to NCB also.
There must be somebody appearing on behalf of the NCB.
Usually an ASG appears.
Union
Just inform either Mr. Natraj appears or Ms.
Bhatti appears.
Inform them. And then call somebody on their behalf and we'll give a date.
This issue has already been decided against the revenue millers. This is like reported judgment. Add up cases for anything.
This is 41.
41. 245 HA. The High Court has read down the Provisional Settlement Commission.
Appeal is dismissed. The issue in question has since been decided in judgment reported as Union of India versus Star Television News Limited, 2015 12 SCC 665. The present specially petition is dismissed in terms of the said fact. Especially petitions artists.
Your Lordship, we kindly seek a pass over in item 42.
Pass over 2016 matter. Who's appeared?
Your Lordship, Senior Advocate Dr. Manish Singh.
Pass.
Well, it's item 43. We've circulated a letter, my lords, is requesting for permission to file a rejoinder, my lords.
Adjournment request of the petitioner. Petitioner is permitted to file rejoinder.
Obliged.
Item 44.
44. Yes. Yes.
And for responding.
The refused to condemn delay in filing a report. We have to be waited for 5 years. But the judges perhaps to retire
And then
file the
the
review.
review.
Lordships in 44, I'm requesting for a week's recommendation.
No, nothing. We'll dismiss it.
My Lords,
This is complete abuse of process.
my Lords, grant me a week's time at least.
Why?
My Lords, the arguing counsel is not in town because his mother is unwell, medical emergency. I'm requesting a
Who's
week's
the arguing counsel?
Anirudh Sangan area, my Lords.
Complete abuse of process of court. When is he coming back?
My Lords, may have it this Friday, my Lords. No problem.
Okay. Noted this coming up. Maybe 50 matches.
keep summary. At request of counsel for the petitioner who submits, it is submitted that the petitioner's counsel is unable to attend the court on account of indisposition of his mother. Request for adjournment is give a specific date.
Item 45. And I am appearing for the respondent, saying, what the right later. And I think there is a letter circulated. Item 46.
Lords, I appear for the petitioner in item 46. Pursuant to my Lord's I appear for the petitioner, my Lords, pursuant to my Lord's directions. They have filed an
affidavit.
My Lord, I have only one request, my Lords. My Lords, let the daughter's relationship with the father continue. I'm not seeking any specific orders, my Lords, but let there be a direction that the mother will facilitate phone calls, and as and when the daughter is comfortable, may meet the father, because she's 13 years old, my Lord. Let her not be deprived of her father's presence in her life.
I want to say one for Mr. Belot. When I've been Calcutta High Court Belot, my senior is a Bhagwan Mukherjee, who became judge of Calcutta High Court, and they have the Chief Justice of Rajasthan High Court. They gave me one suggestion in my one matter, had to settle. Consequently, Belot, I still carry the same advice. My Ashwat senior, that I know more.
Mr. Gupta, what do you say?
Now, tell me. Things, see, born, so I born, 13 God, all education I'm taking is. See, he never went to school for admission. Even when you ask him for the divorce, and has it been? My father, no, at the deathbed, my mother died. I was a brother.
See, today,
I want a divorce.
see, the point is both of you are fighting.
Fine. I will.
Both the spouses are fighting. But ultimately, the daughter remains.
I will take care. After he sees me from my childhood.
So now, let to complete this year.
Mr. Gupta and I know each other. Mr. Gupta, you have taken care, nobody is disputing that.
I will take
You will take care, definitely.
I will bother.
All right. Just listen for 2 minutes. After all, when the child grows up, she will need the assistance of the father. If she wants to become a doctor or she wants to go abroad or something, she may need financial assistance. So, at number one, at some stage, she may actually want to have some link with the father. So, let the fight between the two spouses, if we are ending today, not also end the relationship with the father. If the father wishes to talk to the girl and interact with her, and she is willing to do that, to facilitate that.
They are trying. Recently, my Lords, as
one night from childhood
to my daughter, and my Lords, I have perceived there is an emotional bond between us.
2010, she born. Until 30 years, he never tried to care.
That may not be true, my Lords. There is an interim order of the High Court that we were to meet
my Lords. He was powerful man. He will kill me.
That may not be true, my Lords. It's contrary to the laws, my Lords.
I want to divorce from him.
Insisting that I
lost my mother.
Every month.
I've got no brother.
As and when the daughter.
Let me give you some peace, of life. 30 years fighting.
Daughter may not be deprived of my presence, my Lords, in her life.
Yeah, ultimately, when tomorrow, God forbid, something happens, the only blood relative that way would be the father. The father, let us not alienate the father completely. He has his responsibilities, legal responsibilities. And if he is willing to now establish some link, it is not too late. It is never too late.
Very good DI.
My Lord, High Court granted me visitation.
Very good DI. Harassed me. New DI.
This arrangement is still COVID.
30 years never came.
No, my Lord.
I have to be a whole.
There was an order of the High Court granting me visitation.
No.
That was complied with, my Lord, still prior to COVID. After COVID, it has not been complied with, my Lords, because the mother has refused to even let me speak on the phone with my daughter, my Lords, let alone complying with the order of visitation.
Make an observation, but don't come back with some application or.
My Lords, that's why my request was not for any specific order or direction, my Lords, just that mother should facilitate phone calls as and when.
I don't want further harassment. I I don't want further harassment.
My lords, will ascertain the daughter's wishes then, my lord. She is 13 years old and there is a bond between me and my daughter, my lords.
What is the harassment to you?
No, I know he's right.
Mr. Gupta,
Very powerful man.
Mr.
Money
Gupta,
man. My
we know each other. We only represent clients. We should not come in the way and become their mouthpiece.
I
My
agree to
lords,
that.
ascertain the daughter's
What is all this? Ultimately, if the daughter wants to talk to the, you can't be so.
You should visit the house.
No, my lords, I am requesting for
What is
phone
this?
calls and video calls as and when
Now the man is going to be.
my lords, I am not requesting for any order.
Take down. These parties have moved. This is a joint application.
My
No,
lords,
no.
it's by him and I have consented to.
She lost in the High Court, and I compared to that's sufficient. No other way.
What is the application? IA number 1064.
106407.
This is an application by the respondent wife seeking a direction to dissolve the marriage of the parties, between the parties. So, this court should notice to explore the possibility of a mediated settlement. So, during the pendency of these proceedings, the respondent wife has moved the present application. So, counsel for the petitioner has expressed no objection to the grant of the claim for dissolution of marriage in exercise of this court's power under Article 142 of the Constitution. So, next paragraph. Learned counsel, on the previous date of hearing, learned counsel for the respondent had submitted that the request for, we would ask for alimony, no?
Yes, sir.
For alimony would not be pressed. So, court had required the filing of an affidavit to that effect. So, the respondent has in fact placed an affidavit to that effect on the record.
Yes, fine.
Next paragraph. The parties, a daughter named, what is her name?
Pritha.
Pritha Sarkar.
Pritha Sarkar
30 years old.
was born out of wedlock. She's currently aged 13 years. So, the next paragraph, having heard counsel for the parties, court is of the opinion that the agreement arrived at whereby their marriage will be dissolved, is voluntary. So, the counsel for the petitioner husband had requested that the court may make certain appropriate observations or orders with respect to the interaction between him and the daughter who is in the custody of the respondent wife. This court is of the opinion that even though question of custody has not been agitated, the request of and given the fact that the respondent wife has been responsible for the upbringing of the daughter, nevertheless, it would be in the fitness of things that if in a given situation, the daughter expresses the desire to interact with the father, she should be allowed to do so.
And lords, conversely, if I want to interact with daughter.
Likewise, in case the petitioner seeks to establish links with the respondent, with the daughter, with his daughter, the respondent would react positively and facilitate the process. Subject to the above observations, the court hereby dissolve the marriage of the parties in exercise of its jurisdiction under Article 142.
My lords, one more observation, my lords. We direct her to share her telephone number with me, my lords, because she is not reachable, my lords, and the number keeps changing.
One point. For so 1 year, he is not giving me my daughter.
My lords, I can show from records that
1 year.
I can show.
I put the High Court order.
I'm not pressing my application.
They are,
I can
they
show.
are counting and fighting. It's very bad way.
It's water under the bridge, my lords. I can show everything from my app. It's no, my lords.
See, you don't pay the money to
False
the daughter.
statements, my lord.
Some
The communication, including the sharing and her number. So likewise, the petitioner shall also take appropriate steps to remain in touch. Periodically, remain in touch periodically, preferably once a month.
Great for me. My lords, may direct him to share a number with me.
Yes, yes, they have said.
Great for me. Very
Will
good.
you please provide the number? Tell it.
actually, no.
Great.
There is order. I know. So I was telling about.
Yes, yes.
But
I know that.
why he is not given money for 1 year? No, or not even. Case is
If
pending.
you want to open the case, I will argue the case, my lords. That's not true, my lords.
Now, Item 47.
Great for me.
I'm grateful.
Yes.
My lords, this was the matter I was mentioning. Learned AG is leading me, my lords. He's in some
What it survived because the issue of suo motu has now been settled.
Yes, my lords. On suo motu, there were two issues that we raised actually. There was one suo motu which goes against, my lords, which goes against us. The second issue is, my lords, jurisdiction of NGT under section 17, whether it stands
That implies compensation, etc. Why should we keep that issue open?
my lords, because this issue will have to be decided, my lords.
It will be decided in future. We'll flag that and keep it open.
My lords, what we are praying is, if my lords in the end are not convinced on the aspect of compensation to them, my lords may grant compensation to the dependents, but decide the issue of law. That is, my
The
lords.
question is, if it's a plain issue of law like this,
Yes, my
we'll
lords.
keep it open.
But my lords, then it could be decided now because
Why should we? I mean, this is Rose case where you see we might actually decide the other way. Why should we say that?
yes, my lords.
If this is not a normal. I mean, what was the?
My lords, the issue was they were repairing a pipeline, my lords. There was a pocket of CO2 over there, my lords. They removed their masks while talking to each other. And therefore, my lords, they inhaled CO2 and died on the spot, my lords. Before,
Please do not invite an order.
my lords, I'll be able to show from the record, my lords.
You may be able to show, but still we may uphold the order.
My lords,
And
that,
in law it will prejudice you. Why should
my
we
lords,
say that?
that prerogative is always with my lords.
Not
My
a
lords,
question
we
of
can only-
prerogative. It's ultimately what is right.
Yes, my lords. So that's in law, my lords, if we can show. My lords, in law, I can show, my lords, that section 17 bars. Because, my lords, there are two.
Decide it right now. Please argue.
My lords, I was requesting.
No, please, this has gone on. This has been, last time also you did the same thing.
No, my lords, I briefed the learned AG, my lords. I got a
Learned
message.
AG has not come in
As my
the
lords,
last
please,
3 days.
then I will make my submission.
Yes, please.
Would my lords first kindly take up section 17 of the NGT Act?
National Green Tragedy Act.
Also set it out at page 74.
Yes, 74. Yes.
May I just place it for my lord's consideration? Where death or for injury to any person other than a workman. So my lords, there's a clear exclusion that if death or injury is to any person other than a workman, or damage to any property or environment. My lords, in this case, damage to property or environment has not occurred. There's no such finding of the tribunal, my lords. Has resulted from an accident or the adverse impact of an activity, operation or process under any enactment specified in Schedule 1, the person responsible shall be liable to pay such relief or compensation for such death, injury or damage under all or any of the heads specified in Schedule 2 as may be determined by the tribunal. Now, my lords, it's our respectful submission, my lords, that legislature has specifically excluded workmen and workmen has been defined, and I'll show that. The reason being, my lords, legislature already has in place two specific and special enactments, being the Workmen Compensation Act and the Employee State Insurance Act, my lords, which prescribe and provide for acts in the event of death or injury from accidents to workmen while at the workplace. They provide for a manner in which compensation will be determined and paid to the workmen, my lords. So in this regard, if my lords would now kindly just see section 2O of the NGT Act, my lords, which is at page 70.
17.
70.
Yes. Right.
Now, my lords, it says workman has the meaning assigned to it in the Workmen's Compensation Act 1923. So to see whether or not these people were workmen, we have to go to the Workmen Compensation.
Just answer one question.
Yes, my lords.
Under the Act,
Yes, my lords.
the jurisdiction of the tribunal to grant damages or relief is not structured. Is it structured or not?
My lords, it is structured, my lords, in a manner of speaking. It is structured.
How?
Yes, my lords. If my lords would first see, two broad headings are given, my lords. The National Green.
Structured in the sense that, like you have in the Workmen's Compensation Act or Motor Vehicles Act, you have, or
there's a form, my lords, in that, if that's the query, my lords, no, there's no such formula provided. It will always be based on the law, my lords, that what is the loss or damage caused.
tortious, that
Yes.
tortious land.
That's right, my lords.
Therefore, there is no structure, which means that the tribunal is free to choose the method and the quantum. Right? Whereas in the Employees Provident Fund, not employees, Workmen's Compensation Act and the Employees State Insurance, there are caps, which means that legislatively there is a classification. If you want us to invite from that classification, we have no problem, even though it's an appeal. We will. If you press this, we will.
My lords, I'll show judgment.
That classification, we will.
My lords, I understand that.
Pressing it, we will. It's not a threat, because prima facie it seems that this is completely irrational.
No, my lords, I'll show that, my lords, why it will. If my lords.
Supposing that there are two people, one inside and one outside.
Yes, my lords.
According to the law, the one inside will get a structured compensation which would be far less than what is given to a person who stands outside who is not a workman. Let's say somebody inside the premises who is not a workman. No, he may be an employee who is not a workman. He will get more. I hope you follow.
Yes, my lords. May I respond, my lords?
Workman has a certain connotation.
Yes.
Contractors, employee may or may not be. A managerial staff will get far higher compensation. Workmen will get what is there under the law. We'll have to see that.
Yes, my lords. So may I respond to that, my lords? Because that's a pertinent question my lords have put to me, my lords. My lords, even under tort, my lords will always go by a principle as to how that damages will be computed. Because my lords have said even in personal injury matters, it does not mean that there will be a windfall gain. There will still have to be some aspect on which the damages are computed, which my lords have always taken as what was the person who has died.
In tort, I doubt whether you.
Yes, my lords have. My lords, I'll show those line of judgments.
We don't have a structured law in tort. If it were, it's very important that we should, because then you can go into general damages, special damages, and the scale can increase.
Yes.
But we don't have. We do more of an ad hoc. It's more of an ad hoc exercise in the case. Whereas in a structured one, you actually go into the income, and then we have also artificially, judicially imposed caps, etc.
So, my lords, in tort, as my lords know now, there's some legislation which deal with tort liabilities, like the Motor Vehicle Accident Act.
This is also torture.
Yes, my lords. My lords, the Consumer Protection Act.
Of the general tort.
Yeah.
In general tort, there is not much structuring happening in India.
My lords are right that there is no specific judgment on the aspect of what is the.
We have not developed tort jurisprudence.
To that extent, yes, my lords. Now, my lords, my respectful submission there was, my lords, as the law stands today, my lords may develop the law. My lords, as the law stands today, even in tortious liability, my lords will always still go by the concept of by far section 73 compensation. That means putting the person back into a position that person would have been in the event that accident or injury had not occurred. That is how my lords have till now interpreted these laws. Now, my lords, if given that aspect of the matter, My lords, we in the Employees State Insurance Act also, my lords, what is seen as their wages, my lords, and that wages itself is being paid. So in my respectful submission, there won't be an unreasonable classification here. I will be able to show that if my lords permit me. And my lords, insofar as tortious liability is concerned, this issue specifically arose before this Honorable Court in 1997, qua the ESI Act, where, my lords, under the Employee State Insurance Act, the employee obtained the benefits
That
and
was
then
the
sued
case.
for tortious liability.
That was where we didn't have the NGT.
Yes, my lords, not the NGT, my lords. It was a suit for tort, my lords. So, my lords, on the principles
That's
of
probably because you have a law, you would say that that stands excluded.
yes, but my lords, that's the test, or that's, my lords, what we are today praying that Section 17 still, my lords, the legislature still wanted to keep workmen as a separate classification. Yes, my lords. The judgment, my lords, is 1997, 7 SCC 638.
This is Ramaswamy's judgment.
My lords, this is Justice Majumdar and Justice Kirpal, and authored by my lords, Justice Kirpal.
1997.
1997, 7 SCC 638. Listen, my lords, though NGT was not there, this is on the general principle, section 53 and tortious, if there's a tortious liability, whether it can...
3 SCC.
Please, my lords. So, I'm so sorry, 1997, 7 SCC 638.
This from the other claims available under law. Exactly.
I just place the facts from the head note, if my lords permit, because instead of reading 2-3 paras for the facts, my lords.
Yes.
My lords, from the head note itself, my lords, the respondent was an employee in the plywood factory of the appellant company. While feeding the DAP compound in the roller mill by pushing the same with his hands, the respondent met with an accident. However, he was allowed by the appellant company to continue in service without any reduction in remuneration. While still in service, the respondent filed an application in civil court under Order 33 Rule 1 seeking permission to file a suit. This application, although in view of Section 53 was dismissed by the trial court, was held by the full bench of the High Court to be maintainable. Opposing the instant appeal, the respondent contended that Section 53 should not be construed in such a way as to prevent an employee from bringing about an action in tort. So that was the test, my lords, the query that was raised before this honorable court. Then if my lords would kindly see para 10 onwards. Para 10 and 11. And I'll place Section 53 and 61 also for my lords' consideration, which is referred in para 9. Para 10, if I may place, my lords. May I place para 10, my lords?
Yes.
The position with regard to the claim of an employee against his employer on his suffering an employment injury now stands settled with the decision of this court in A. Trehan versus Associated Engineering Agencies. In that case, Trehan, who was an employee of the respondent, received injuries on his face while he was carrying out repairs of a television in the course of employment, as a result of which he lost vision in the left eye. After receiving the benefit from ESI Corporation under the ESI Act, he served a notice on the respondent demanding rupees 7 lakhs as compensation. Thereafter, he filed an application under the Workmen Compensation Act claiming compensation of rupees 1,06,000. The employer objected to the maintainability of the same and relied upon Section 53 of the ESI Act. The commissioner overruled the employer's objection and followed the judgment of the full bench of the Kerala High Court in the present case and observed that ESI being a welfare legislation, Parliament could not have intended to create a bar against the workmen, claiming more advantageous benefits under the Workmen Compensation Act. The single judge of the High Court dismissed the writ petition filed by the employer, but the division bench in appeal held that in view of the bar created by Section 53, the application for compensation filed by Trehan was not maintainable. This court analyzed the provisions of Section 53 of the ESI Act and observed that so and so as follows. In this background and context, we have to consider the effect of bar created by Section 53 of the ESI Act. Bar is against receiving or recovering any compensation or damages under the Workmen Compensation Act or any other law for the time being in force or otherwise in respect of an employment injury. The bar is absolute as can be seen from the use of the words, shall not be entitled to receive or recover, whether from the employer of the insured person or from any other person, any compensation or damages, and under the Workmen Compensation Act or any other law for the time being in force or otherwise. The words employed by the legislature are clear and unequivocal. When such a bar is created in clear and express terms, it would neither be permissible nor proper to infer different intention by referring to previous history of the legislation. That would amount to bypassing the bar and defeating the object of the provision. In view of the clear language of the section, we find no justification in interpreting or construing it as not taking away the right of the workman who is an insured person and an employee under the ESI Act to claim compensation under the Workmen Compensation Act. We are of the opinion that the High Court was right in holding that in view of the bar created by Section 53, the application for compensation filed by the applicant under the Workmen's Compensation Act was not maintainable. Then, my lords, I'll go straight to para 11, my lords. In view of the aforesaid observation in Trehan's case, with which we respectfully agree, it is clear that the respondent could not make a claim for damages. Section 53 disentitles an employee who has suffered an employment injury from receiving or recovering compensation or damages under the Workmen Compensation Act or any other law for the time being in force or otherwise. The use of expression or otherwise would clearly indicate that this section is not limited to ousting the relief claimed only under any statute, but the wording of the section as such that an insured person would not be entitled to make a claim in torts, which has the force of law under the ESI Act. Even though the ESI Act is a beneficial legislation, the legislature has thought it fit to prohibit an insured person from receiving or recovering compensation or damages under any other law, including torts, in cases where the injury has been sustained by him in an employment injury.
Yes.
So, my lords, we are relying upon this judgment to show, my lords, that, as my lords rightly put to me, that it's a tortious liability.
So, and even otherwise means tort.
Yes, ma'am. And therefore, my lords, NGT, my lords, the jurisdiction, my lords, the legislature would have had all these, the law in mind when they were enacting the NGT Act in 2010, my lords. And keeping in view that position, my lords, they have excluded workmen because Section 53 and 61 of the ESI Act specifically bars the person from getting any benefit. And NGT in this case, my lords, while granting compensation, says this will be over and above what is granted under the ESI Act. So, my lords, that's the respectful submission. Like I said, my lords,
there is any higher. So if there is no higher, this will, it doesn't say over and above. It says if there is anything higher.
No, would my lords kindly
see that last part?
Yes, my lords. Kindly see page 22 immediately, my lords.
It's also very structured.
Here, my lords, they go by under the MACT Act, as my lords have given a multiplier factor. That is
right. So what is the
what we are aggrieved by is the
to ESI here.
Yes, my lords. We've placed that on record that they are now being paid under the ESI Act.
Now, what would the amount
when the incident happened? Yes.
If they are a higher claim. The point is, if they have higher claims.
No, my lords, the NGT, I wish had said only that if my lords would kindly see page 22, around 10 lines from the top. Any payment, my lords, if my lords has that, after they've computed it, and after my lords, what my lords have pointed out, however, if they have a higher claim, they can go there. But please see after that also, my lords. Any payment made, already made towards compensation for death may be excluded from the amount which, but not the ESI scheme or the monthly payments under the ESI.
That will not be excluded. That will be taken into account.
My lords, so what they are saying is that this ESI Act will be paid in addition. And my lords, what we've done is we've computed this.
Any payment already made towards compensation for death may be excluded.
That's right.
But not the employee's deposit linked insurance scheme or monthly payments. That will not be excluded. So which means that this will be included for computation of that total amount.
My lords, but then kindly see how it will happen. Under the ESI, my lords, it's over a period of time that the money is paid. It's not paid in one time. My lords, under the NGT, if the NGT gives me a direction that to pay that amount, then my lords, that means then I have stopped paying the monthly amounts. It creates, if that is the issue, my lords. How we read it was, my lords, that the NGT is saying that this will be over and above. You will exclude the amount ex gratia payments that you may be making, but the ESI amount you will continue to pay. We've done a calculation, my lords, based on the life expectancy, etc., of the persons. If I may just pass on this chart, my lords, under the ESI Act.
My lords, over a period of 20 years or something, you'll pay this.
So, my lords, because this is, my lords, as my lords know, it will be paid monthly. It is idea is to, my lords, see that the person who was the bread earner, my lords, doesn't leave the family in penury. And this is over and above compassionate employment.
What does that?
Yes, my lords, the first one who died, my lords, Mr. Abhimanyu Saha, the NGT has calculated 30 lakhs as compensation, my lords, based on
229 lakhs, 229 rupees will remain the same throughout.
Throughout. My lords, though, no.
What for the lifetime of?
She'll get around 30 lakhs 69 if she survives till 70. If she survives more, she gets more.
What is the 30 lakhs over a period of time? 229 now and 229 10 years later.
No, my lords, there, under the ESI Act also, the government keeps coming out with circulars, my lords. There it may change. So it's not that, my lords, it will become stagnant because the fund, as my lords.
Have you actually examined?
My lords,
the ESI, now many of them are getting just 1,000 rupees, 1,200 rupees, 1,500 rupees. And coming from a public sector undertaking.
My lords, we have to. My lords, we are on the as my lords know, my lords, we are on the principle of law, my lords, because as employers, we need to be aware where all our liabilities lie. And here, my lords, the NGT doesn't find that there's been any negligence. On the first date itself, my lords, we are called upon suo motu notice. My lords, we submit our reply. On the first date itself, NGT.
Where have you said where's your reply?
Yes, my lords. My lords, my counter is at page. Sorry. Page 139, my lords, my counter begins before NGT. And my lords, there's one more error, my lords, in my respectful submission. The National Green Tribunal says these people are not workmen under the Workmen Compensation Act. My lords, that again I will show under the definition clause itself they fall.
They were contract employees. Question is, was this contractor authorized?
Yes, my lords, authorized, and my lords, I'll show from the definition itself that even contractual employees who have been taken for repair work for a pipeline will be covered under the definition of workmen.
Let's see your reply.
Yes, my lords. Page 139, my lords, I was showing. My lords, first we mentioned the entire incident. My lords, how the incident took place. My lords, what were the safety protocols that we followed. My lords, will see at page 143 is the safety protocols that we placed on record, my lords. And then we pointed out, my lords, step by step what was the process that we undertook. So if I may just explain, if my lords want me to.
Yes, Mr. Panda,
and last time perhaps your lordships wanted to hear from the side of the workmen. There is nobody who will be representing the workmen. I am for the state pollution control.
That's why we moved an also application.
Perhaps your lordship may appoint some amicus.
All right, we'll appoint Mr. Keshwani. You appear.
Please, sir.
Please go into the matter.
Yes. Obliged.
We have heard counsel for the appellant and the reporting member. Since she is workman represented, the request suggested that an amicus is appointed. Representative Mr. Keshwani, President Keshwani is hereby requested to appoint to appear. and assist the court as a matters. Please give him a copy.
I will, my lords, provided you.
The paperwork shall be provided at preference for the petition. For the appellant, list on after 6 weeks. You can file this.
I'll file this also, my lords.
As a okay,
So great.
What are the question for a pass is on Dharmadhikari is on legs in Antikon.
So what is the mapping?
The issue relates to payment of my pensionary benefits. It's been stopped after 36 years of service because there is an interstate dispute in the college management and I am left in the lurch. Earlier, of course, my counterpart ought to have taken liberty while withdrawing the writ, but I would still make it good that there's a fresh cause of action. So if the doctor wants to hear it after a Passover, what is it?
Who is appearing for the, who appears?
I am appearing for respondent number 6. After filing of the Wakalatnama, we have no instructions from our client, so we may be treated as discharged.
That's all right. So whom are you seeking Passover for?
For respondent 120, Mr. Dharmadhikari appears, my lord. He is an another for. My lord, we pass over the matter.
Passover.
I thought for the substantially the same.
And as an item 49.
The impugned order is because he withdrawn the earlier.
Earlier without liberty. So, but I'll make it good that there was a fresh cause of action. The subsequent.
What about your prayers? The prayers?
Prayers are almost similar, Manoj, barring one where they said I wanted a narco test earlier, so that would be an abandonment. I've left that prayer.
Why?
That was totally
Why
misconceived.
narco test?
I don't know, Manoj, because there was a dispute among the management. So I said the current management is lying, so sent him for a narco test. That was my earlier round, which was absolutely misconceived. So that of course I have abandoned. So I am more on my pensionary benefits. Well.
I think 49 November, I'm seeking a Passover.
49 and for the petitioner, you know.
You are
For
for
responding 1, 2, 3, 4, 1 and 2 are present in 4. My lords, if 3 and 4 are not in India, they've not been in India for a very long time, they are not in, is what my understanding.
Last time there was an order for them to deposit their
so that's all right. We want to know one thing.
The mother
We
is-
are asking them. What are the assets? Do we have an idea?
Yes, my lords, that is there along with the testamentary petitions in if I may just take my lords.
Your
lordship have corrected
them time and again.
Yes, we are aware. Please let us also,
My
let's
lords,
understand the totality of it.
an extra A of my counter affidavit, running page 11. I'm just pointing out, my lord, Ms. Nisha is leading in this matter since my lord is asking me a query, I'm just assisting.
Please tell.
Please, sir.
Now this, who is in possession of what?
My lords, my understanding is the Kirtinagar property is in the possession of the son. I am residing, as the mother, respond number 1, I'm residing in the M50 Radhe Mohan. The rest of the properties are not in my possession.
Now, see, this is as far as immovable properties.
Even for the movable properties, the
No, 1 minute.
yes, sir.
2, 3, 4 are immovable properties you are not in possession.
In immovable,
Sorry, 2 you are in possession.
2 I'm in possession.
1, 3 and 4 you are not in
I'll
possession.
just verify it, my lords. Hello, sir. I just want
Just a minute. We
The
are hearing
2
your
and 3. The 2 and 3 we are in possession of. 1 and 4 we're not in possession of.
1 and 4, you are in possession of 2 and. Then what about this Dubai property?
Yes, that's right. Yes. Everything else is with the son itself, except those shares which are the subject matter of the present dispute.
That is, the shares are mentioned at, where are they?
My lords, they are mentioned at page number 14, my lords, at serial number 1, which is the details of movable properties.
14 at number 1.
Yes. Everything else is in the possession of the son.
No. This particular shares for which the
Please,
in passing order.
Yes, my lords.
Now that is not in India.
They're not in India, my lords.
So you have control over that. You transferred it or whatever you did.
Your Lordship, the details of the shares are at page 13, item 1.
Spiritual Developers Private Limited.
No.
It is late Shri Sudhir Kumar Oberoi had 73,87,250 shares in Mezan Holding Company.
That's what I was pointing.
That is at their counter affidavit, page 13.
Serial number 1 of the
Serial number 1.
properties of Dubai, Kuwait, and United States of America. That's what I'm also saying.
Yes.
And I have done a basic evaluation of the properties that are in the possession.
1 minute.
Yes.
So number 1, number 2, and number 3 are also in your possession.
No, my lords. Immovable properties only 2 and 3.
Forget movable.
Yes.
I'm talking of movable.
For movable, only 1, which is the shares in the Mezan Holding Company, for which this court is seized with the matter.
Now what about S. Oberoi?
Not with us.
You have it.
No, we don't have it.
You have it,
Yes.
sir. You have the possession of shares in S. Oberoi.
Your Lordship, I'm not sure. I will have to take instructions on that. But after the court order, I have not transferred anything in my name. That is a statement I am making on instructions, and they have done that. Why they have done that? If Your Lordship will allow me a minute, I will clear that. But
To the testamentary proceedings.
My lord, it's still at a preliminary stage. The
issues are yet to be framed.
Now, what is the next? What is your
I've filed an application for recall of 2 orders, my lords. 6th May and 3rd of February. By order of 3rd February, my lords was pleased to issue bailable warrants against me, pursuant to which I have appeared. My lords had also directed us to deposit our passports and had put an embargo on us leaving the country. With regard to that, my lords, I am ready and willing to give an undertaking that as and when this court calls me, I will appear.
That's not the point. The point is, each time we required your client to do something,
my lords, I understand. I have the entire.
So we make sure that part is complied with.
My lords,
that part is complied with, we will
lords,
do everything that you need.
Please, my lords, for that.
We will not recall the order till you comply with that order.
My lords, that's why I have sought recall of both.
We will not. We will simply dismiss it.
Two orders.
Simply dismiss it on the ground that you defied the court's order.
Not at all.
We come back with the order. All kinds of things were said that the court there in Dubai doesn't permit. We don't know. That company, the chartered accountant is in charge of it, etc. We don't know anything.
Please, my lords.
Here, as far as now, it seems that you're now finding it a problem. So we will not pass any orders on this till you comply with the and you will have to, because you see, Ms. Juneja, no?
Please, my lords.
Ms. Juneja, the problem is each time we have required something to comply,
Please, my lords.
a new council has come.
Please,
So you are the latest in the
I
series.
understand, my lord. I've seen the order sheet. I've seen the order sheet.
We don't know what assurance we can get from anyone because each time the council says something,
Please, my lord.
unfortunately he or she cannot come back and face the court, or they replace the council.
Which is why
there is no assurance for
my lords, which is why my request was that the petition respondents 1 and 2 will give their own personal undertaking before this court. First,
we are not concerned with undertakings.
Second, I will just point out.
First, sum and substance is, tell us how to ensure that these properties secure.
Please, my lords. With regard to that, I will just point out the order of 6th of May 2023
is the 22 is when this honorable court had directed monetization and the registry deposit in the registry. At that stage, an impression was given to this honorable court that the respondents herein are evading service. I can place an additional affidavit on record along with all my documents to show that respondent number 2, 3, and 4 were not even in the country between that entire period when the service is said to have been effective.
Once the service is done,
it was only done in August of 2020.
whatever it is, Mr. Juneja, the point is, once you are aware that this is the order, you comply with it. The monetization has to happen. After that, we will grant you all the relief. You do it. Till then, we will not do anything. You take your instructions if you want.
I'll also then keep it for Friday.
Why Friday? You keep it. You take your own time to comply.
Well, I'll keep it for Friday. I will come back with proper instructions on all the orders and the directions given by this honorable court. Whatever legal impediments I will have, I will place those also for this honorable court.
You don't even know whether you will come back.
I will be there.
Your Lordship may allow me 1 minute only.
Yes.
Why it is happening? Why it is happening?
Excuse me, sir. See, this boy, he took all the property in Dubai, and cash it. He took my house, 6-bedroom house. Number is 715, District 1. He took that also. And
He's your son.
Biological son.
I can't say this is my son. This type of son can't.
You see, Ms. Oberoi, you may have your problem. We have
You know what
difficulty in understanding that there is a problem. Only thing is, we want you to comply with the order. Once you comply with the order, we may actually call that your son also ought to be present here.
Please call him. Please.
No, we will not do it at your dictation. You will have to comply with our order, then we will do what we think is right.
You please call him because
we will not call him till you comply with the order. Please.
Okay. And second thing, he sent the police in my home, and being a senior citizen, I didn't get up in the morning. 7 to 8, 6 people came to my home from the police station. They are troubling me. Please stop this and just tell them not to do like this. I'm an elderly lady and my legs are not working. I told you last time also. Please help me.
She has deposited the passport?
No, my lords, with regard to that, from the travel agent also. What had happened is the respondent number 2, her son stayed in Switzerland. It was his birthday on the 16th of February, because of which she had given the passports for Schengen visa. When after this order of this honorable court, she's asked for it back. I have that letter from the travel agent also. I can show to my lords that I had given it to the week, and which is what is
anyway, we're keeping it on Friday.
And Friday.
You will come back and deposit if you have not deposited.
Your Lordship, one submission only. First, Your Lordship, the office report says, today's office report, the report from the police is that they deliberately did not deposit the passports, and on the premise that they have given it to the travel agent. We all travel to foreign countries. Original passport is never given to any travel agent. VFS service, yes, it is given, but never to a travel agent. That is one. Now, Your Lordship, why they are delaying? In my rejoinder at page 3, I have highlighted how the shares of this company are going down and the estate is depleting. And at page 8, Your Lordship, I have said that last year they have taken approximately 2.8 crores of dividend, about which they do not speak a line. And in another 3 months, another installment of this dividend is likely to come. They want to wait for that and pocket that. In defiance of the orders of this honorable court. Only two.
This is a sad state of affairs where the son is suing his mother for the properties of his father, late father. He's not even had consideration in that regard, my lord. Only that is all I'm saying. I'm here.
I tried to contact on 18th of January. I messaged my mother. She did not respond even. It is not so. It is not that. It is not correct.
Let them comply. Please, we will tell you one thing.
Please, Your Lordship.
After all, they are all blood relatives. So we will take
biological father and mother and son. It's not even a step.
I don't know, what is your age?
He's 37, 38, my lord.
Around 38.
38.
So if you are not satisfied, we will simply dismiss it. Right? Now, we may at some stage require you to come and be present in the Delhi High Court, because who has filed the test?
Both of us have filed.
Both have filed.
Both of you should be present.
My lord.
Your Lordship, we are ready.
Can we leave and again join?
Oh यार इतना टाइम नहीं होगा, do it.
probate, the other one is letters of administration.
Both
Both are probate. Both are.
cross
There
probate.
are two wills now.
Two
Yes.
wills.
One is a 2000.
One is in my favor, that is a registered will, and 26 days before the death is another will in her favor,
That's all.
which
So
we
this is
dispute each other.
Which will show the true state of affairs, my lords, as to why the father had to reach that situation.
Depending on what they do, we may actually not even exercise our jurisdiction. We're telling you in advance, because this is after a point of time. This is after all in a contempt. A contempt you come in appeal, and how far we can take it, we don't know. So please keep this in mind. We will ensure that there is compliance with our order, and thereafter, what we have to do with you, we will also take care.
Lordship, I am ready for all things. I am ready for expeditious.
Not expeditious. You may have to be present here in the court, in the High Court, and going for some kind of mediation. This is not.
Lord, may I request if that's possible?
Maybe you're right that they have not done this. This is not our way of dealing with it.
If your lordships will desire that, we will do that also. We will go for mediation as well. If it desired and it is feasible, there is no problem.
Necessary, I may file in the meantime for my lord's
This is
consideration.
open to the respondents to file additional affidavit in the name.
May I also request if the mother can be exempted from personal appearance, the daughter will be exempted.
What is her name?
Miss Neelam Oberoi.
Neelam Oberoi.
Is hereby exempted from personal appearance for the time being.
Much obliged.
Thank you, sir. I have one request. If you won't allow me to come here, I can't come.
We have done that.
Okay, thank you. Thank you.
Oblige you, Lord.
On the last occasion, my lord has asked me that if my lordship something can be worked out between the parties. I have actually spoken with my client, who is the husband, my lord. The Honorable Trial Court has actually directed the maintenance amount of rupees 10,000 per month to the wife, and the Honorable High Court has, my lordship, reversed the finding and has allowed my appeal. The wife is already having 5 acres of the land, and I have also filed the revenue record, which is also the part of the trial court. My client says that 5,000 he can afford, my lord, to pay. Like because it is not the position that she is like completely hand to mouth. If my lovely friend agree to that.
Lordship, may I submit to your Lordship? Lordship, if your Lordship will kindly see the finding recorded by the trial court, he has around 45 to 50 acres of land, your Lordship. It is a case wherein before dissolving marriage with me, he has entered into second marriage. Now, what the respondent is doing is, your Lordship, he is transferring all his land in the name of his son. The amount of maintenance which has been awarded by the trial court is 5,000 only, your Lordship. I must agree to that. But if your Lordship, I kindly see the situation. In 1982, these parties got married, your Lordship. She stayed with the respondent only for 2 years. Thereafter, he has thrown her out of the house. He has entered into second marriage. Now, till my father was alive, your Lordship, I was dependent on my father. My father died, giving me 5 acres of land. That is an admitted fact, your Lordship. I must admit this. But that land is being cultivated by my brother. It is not in my hand because I am not in a position to do cultivation. It is only after my father's death, your Lordship, I'll file an application for maintenance, seeking maintenance from the respondent because there is no one to take care of the petitioner presently, your Lordship. So awarding 5,000 rupees would be very less, your Lordship, even if we compare with the status of respondent. Because there is a specific finding which has not been controverted or rebutted and by the respondent. Even the High Court has not given any finding contrary to this. If your Lordship will kindly turn to page 53, this is the finding recorded by the trial court, wherein it is specifically stated, your Lordship, that he has around 43 to 44 acres of land. Respondent. Even then,
the income out of the land is also mentioned, my lordship. It is not a city; it's a very rural area. The total
it's an agricultural land, your Lordship. Very fertile agricultural land.
Kind of
That
crop,
is
7 lakhs.
in an acre.
Yes.
Yeah. So it is 7 lakhs a year. So it is 7 lakhs a year, my lordship.
18 quintals, 1,800 quintals of paddy.
18 to 7 lakhs.
1,800 quintals of paddy is harvested
And
in 40 acres of land.
see the other aspect as well. There was an agreement, and if my lord would see at page number 21 of the SLP paper book, what section 125 clause 4 says that if the party mutually decided to live separately, the spouse cannot claim my lordship maintenance. If the parties have mutually decided to merge separately. In fact, there is a two High Court judgment which also says that if by way of an agreement, the parties decided to live separately, then like the wife cannot claim maintenance. Although there is no Supreme Court decision on that point, but if my lord would want,
there is a Supreme Court decision to that effect.
Two High Court judgment with me, my lordship. The other aspect is that, my lordship, after 14 years, they have entered into the agreement that they will live separately and that they will not file any.
When did you get married?
1982, my lord.
No. Second marriage.
2000
marriage, I don't have the date, my lord.
Your Lordship, it's recorded in the trial court order. The marriage, he entered into second marriage in the year 2002, and the so-called compromise agreement was executed on 24th.
There is the trial court.
Yes, sir.
The
43.
The parties live in the village and they belong to the OBC category, my lord.
Page 43, top.
Page number 43.
The non-applicant, Your Lordship, has to be from page 42 it starts, Your Lordship, bottom. It is apparent that non-applicant had solemnized second marriage prior to sending notice year 2002. Therefore, applicant has not mentioned the fact of second marriage in the notice exhibit issued to the non-applicant. On this basis, this statement of non-applicant that non-applicant solemnized second marriage after proceedings of dated 24/3/2003 does not appear to be true. This is the clear finding of the trial court, Your Lordship. Then, at para 29, the learned trial court recorded a finding that the marriage cannot be dissolved merely with the consent of the party. There has to be a decree of the civil code, because the respondent has not given any evidence to show that in the Patel community there is a custom that the marriage can be dissolved through consensus.
If
And was this agreement of 20 lakhs or 10 acres?
it is an oral agreement, my lordship, and even as per the trial court.
It was on the date, Your Lordship. The contention of the petitioner is when this compromise agreement was executed, it was assured to the petitioner that
was in 1980s.
No, 2003, Your Lordship. 2003.
When is that agreement?
The agreement is not on
It
record.
is only an oral, my lordship, assertion which the.
Mr. Kaushik Shukla, there are two. One is obvious, we will not interfere, or we'll ask you to pay some. The other is we will go into the merits and restore the trial court judge. Then all your contentions are there. She can actually get maintenance from you.
Balarji, obviously, I'm completely modern to my lord, my lord. But
we say there is an agreement from which it appears. If it is an oral, how can it be High Court?
There is only
D2.
Where is actually Exhibit D2? It is there.
Your Lordship, it is not on record. It is not filed.
You must be having a paper book, High Court paper book with you.
Your Lordship, it is reproduced in the impugned order, Your Lordship.
No, it's only referred to.
Only the part.
The order of the learned judge which is under challenge is also in agreement.
My lordship, in the counter affidavit at page number 11 is the agreement in English, my lord.
Page number 11 in the counter.
Yeah, it is the agreement between the parties. I mean, it is the same agreement which is reproduced in the in page 4 of the Honorable High Court order.
Yes, page 11, no? Page 11 of the
page number 11. So, my lordship, the agreement says that no party will have any claim against each other. It is, my lordship, one-time permanent alimony. And, my lordship, as per section 125 clause 4, the parties mutually have, my lordship, agreed to live separately, and therefore there is an embargo of my 125.
There is a finding against you that you got married prior to this. That finding has not been completed or even set aside.
In your lordship, there is a judgment of this honorable court which says that such a compromise will not prevent the wife from 2014, your lordship.
That's the only thing we can do. We will set aside the High Court judgment.
I propose 5,000 rupees a month.
No, you come out with a better offer.
I will, my lordship, because
You
even
pay
last
and
time
then
my
see
lord asked.
what land you can give. Otherwise, one has other ideas also.
In fact, my lordship, on the aspect of land also, we have to discuss that because she's not in a position to
discuss it.
cultivate.
Otherwise, I have other ideas about the land.
I will have a word. Even if my learned friend will also come up with a figure, I can also put it to my client.
Your lordship, on the last date of hearing, an amount was asked from me, your lordship. I took an instruction. What has happened, your lordship, if I'll take a lump sum amount now, then after 5 or 10 years, that amount will go and again I'll be on road. Then again I'll have to file an application for maintenance.
Just find out what you want. What do you want?
But I'll take instruction.
Realistic want land or something, that too can be done. Then again the same problem for you.
Exactly.
Your lordship, may I have it, your lordship, after the holy vacation on any date? On a fixed date, your lordship.
Parties. Yes.
Indeed.
Lord, I'm representing the petitioner. As per the court's clarification, the petitioner has joined the investigation both on Friday and Saturday, and his statement was also recorded before the JM First Class Palwal, and his signature was obtained on his statement as well as the
He has joined the investigation on 24th and 25th mile. But so far as the earnest money is
He is joined, so what is the point now?
but when the specific question with regard to this earnest money which he got, he refused to get it recovered.
Do you mean this is a recovery proceeding?
This is a matter of trial, my lord. I have on record place.
This is the, my lord.
I have on the investigation.
I'm for the statement.
I am for the complaint. I have to submit something. What has happened is after he did the agreement to sell with him, immediately he sells it off to somebody else, even before the expiry of my date, and then claims to have gone to the register.
This may be able to 406
and then my money is used to pay back the loan which he had taken from the bank. And then after having paid the bank, what he does is the present sale deed which he does for the second time, he sells the same property for 1/3 of the price. He tries to sell the property to me at 1 crore and 50 lakh, and then he sells it at 49 lakh to somebody else. Only to avoid frustrate my contract. And that's how I allege that this is a sham transaction. It is more than a conspiracy also. But I'm just pointing out a fact, not to.
Lord,
just wanted to point out the conduct of the.
Lord, if I'm allowed to say something, I will take 1 minute of the court's time, Lord. My learned friend in his counter affidavit on page number 5 has alleged that before the expiry of the date or supposed date on which the sale deed was to be executed, I already entered into an agreement and took a check on 8/9/2021. Lord, that is a completely baseless and false allegation.
Anyway, we are not getting.
Lord, but for that I have the proof that I received the money after the date of the expiry date. So I have
Let's take down the court violation notice. I required the petitioner to report to the investigating officer. So, learned counsel for the state submits the petitioner complied with the direction and has joined the investigation. So, having regard to these circumstances and the fact that and the nature of the offence alleged against him, petitioner is directed to be enlarged on bail subject to such terms and conditions as the trial court may impose. Petition is allowed in that.
In future also, he will cooperate with the investigation.
Definitely, I will do that.
That's terms will
I
be
will do
first.
Grateful.
Yes.
Lordship, the petitioner before the Lordship is seeking anticipatory bail. The petitioner is a 25-year-old boy who is preparing for government services.
Yes.
Lordship, the FIR was lodged on 18th November 2021. Thereafter, I have joined.
Why were you? What is the allegation against you?
The allegation is that the complainant's nephew wanted to get selected in the examination to be held for the post of Patwari. And for that, he came to me and my brother-in-law and paid us 18 lakh rupees. And we sort of represented to him that we will arrange a job for him. But it is totally false, Lordship. I am a boy who is myself is preparing for government job. And I have never contacted him for this money. And I have basically, I have cooperated with the investigation. If Lordship will see, I have attached a letter at page 36 where I have given the details.
The FIR is lodged in October.
18th November 2021.
We are not inclined, sir. We're not.
Lordship, he is a boy of 25 years. Lordship, his entire career will be ruined.
Go back and apply. Notice. No case made out, especially.
Lordship may see the letter at page 36. Lordship, I have joined the investigation. Lordship, see the allegation. It's under 406, 402.
Then they will not arrest you. You submit to them, they will not arrest.
Lordship, if Lordship will consider putting me to terms, Lordship, to show my bona fides, I am ready to deposit some money also.
You go back. Sorry.
Item 53.
Yeah.
Please go. Because we filed just to respond to what your lordships had a concern about. We filed this additional document. Will your lordships have a copy of that?
Yes.
I just want to show you three things from that. The first of which is page. Sorry, you don't.
Yes, we have.
I'm sorry. Page 24.
Can we have a copy?
Sorry, just keep up. Keep up.
24.
Yeah.
No, 24. Only 70. Oh, you giving up?
I'm sorry, we haven't.
There is one additional affidavit.
Yes, well, this is over the weekend. When is this filed? I'm sorry, my misunderstanding. This is being handed over by me now.
The thing was filed earlier.
That was with the original petition itself. That's it. So there are two things I'm handing over. One is that compilation. The second is this annual report. And this annual report, I just address that first. Give this to Alison. This annual report, my lords, is of 2017-18 because your lordships had asked us that if this 2 lakh odd number, a majority of them would be those who had qualified much earlier and the inconvenience being caused to them. If the lordships can come just to the absolute last 2 pages of this annual report. These are those who had been recruited in undergraduate by Neet, who are the ones who will be graduating this year, who are the ones on internship. My clients are this. So if you see the last 2 pages, second last page if your lordships come to, it shows the state-wise details of medical colleges and MBBS seats for annual year 17-18. At the bottom, if you see the total is 67,352. Extreme right, bottom. So maximum, if every single one of these people decide to sit for PG, it would be 67,352. The remaining 1,33,000 or 35,000 would be those who had in fact graduated already in previous years and who have not been successful in their PG admissions. There are a large number of them. We have annexed, in fact, that refund document, the refund page, refund. Refund letter, yes? Page 30 of this compilation, if your lordships can have. The other one, Lords. Now you can leave the annual report aside. This is just to tell your lordships who might be in the fray.
Yes.
In that page 30, this is 24th February, Lords, Friday, when this matter was last heard. This notice is by the DGHS, and it mentions in the first para, it is for information of all candidates who participated in PG 22, last year's PG, that as per the eligibility conditions of refund, the refund of the security deposit made to 60,874 candidates. Please find refund list. So these are candidates who took part and who didn't make it through to PG. Either they weren't counseled through or they were not successful. So 60,874. So there is a large chunk of these who are likely to be in that 2 lakh who have registered themselves for this exam. And there's obviously some more who maybe from previous years, etc. This is.
So what is the inference you want us to?
And one more, which is page 24.
Yes.
Page 23 and 24. 24, if your lordships first sees. This is a list of all the states and their internship deadlines. Please read the notes at the bottom. I won't trouble your lordship with that table.
Yes.
As per 7 January 2023, that is the initial notification which kept 31st March as a deadline. With internship cutoff dates at 31st March, except for Andhra and Haryana, no other states became eligible. So it would be only that small pool of whatever colleges there are in Andhra and Haryana who would have become eligible. Even as per 13th January, which took it up to 31st June, the internship cutoff 30th June, Telangana, Madhya Pradesh, Pondicherry, Jharkhand, Bihar, Chhattisgarh would be ineligible. So now with 11th August, in fairness, I must tell your lordships that there are 2 states which still stand excluded. One is Jammu and Kashmir, and the other is Chhattisgarh. Therefore, the deadline that they have now of 11th August takes care of everybody. And if you come to the previous page, 23, we have shown your lordships the previous years what the practice has been. The internship deadline has been 31st March 2017. And the exam date is given there, 5th December 16. This is what the practice has been in the past. The gap between these are never more than 2 or 3 months.
Which one are you?
Page 23, I'm sorry. The table at the top of page 23.
Yes.
Table which has if your lordship sees between internship deadline and exam date for all these previous years, very small gaps in between.
What you are saying is they ought not to have postponed the internship.
I was afraid that you thought
actually it's not unusual, my lord. Or every time in the past, only 2-3 months gap used to be with the last date of internship. This time the last date of internship, which for before counselling, is 11th of.
That's because this is unusually they have postponed it. How many times did they postpone the internship date?
Twice.
No, not today. In the past, since you have been able to get data.
So last year it happened, same thing happened last year.
What they did this time was when they allowed the first date, they didn't consult the states. So majority of the colleges were not covered. So they enhanced the date, but brought it forward. Again, states were not covered. It's the third age which brings 16 states. And these students of 16.
So past years, when did they increase it?
So the chart, same page 23.
23, sir.
If you see the below chart, the chart below, these are instances where that exam has been rescheduled. If you see the middle one, Neet PG 22-23 and Neet PG 21. Neet PG 22-23, earlier proposed date was 12th March 22. It was postponed to it was postponed on 3rd Feb to 21st May 22. So by 3 months it was postponed.
What was the reason for postponement?
This is at page 46 of the main SLP. It is a notice by the authority itself.
they've said, keeping in mind that many of the interns would not be able to participate, page 46 of the main SLP models, not this volume, main SLP. Postponement of Neet PG 22 regarding, I'm directed to say that a lot of representations were being received from medical doctors regarding request to delay Neet PG 22 examination date, that is 12th March 22, as published in Information Bulletin so and so, since it is clashing with the Neet PG 21 counselling. Also, many of the interns would not be able to participate in the PG counselling 22 by the month of May or June 22. Keeping the above facts in view, the Honorable HFM has taken the decision to postpone Neet PG 22 by 6 to 8 weeks or suitably. Hence, the decision made by Honorable HFM may be complied with. Lastly, my lords, in the SLP itself, page L, if your lordships can see, there is a table at page L. Lord Justice Datta has. So, page L shows the previous years, the date of exam and date of counselling. If I take the first one, January 7th, January 18 is the exam. Counselling is March to May. 6th January 19, then March to May. 5th January 20, again March to May. So it's all just 2-month gaps. Right now we're looking at a gap of more than 5 months, all the way till August. And maybe even longer, depending on when the counselling winds up. There's no particular purpose.
When you make the request for postponement of internship eligibility, you were doubtless aware that
none of us did, to be fair. Those requests were made by others, but not
by you, meaning you as a class.
Yes, large class.
So when that means you were ready right now. If you had not made this request, then you were ready to take the exam. You were ready to take the exam.
I presume those who made that already.
Since you are there before us, you did not make the request for postponement.
No, but
if you have not,
yes,
there are two parts.
No, I understand.
If you did not make the request, then you are ready to take the exam. So nothing has changed for you. So those who have made it, now you stand for some of them.
We were not in a position to take the exam until we were. So until 7th February.
No. Again,
we were not ready for the exam.
I'm confused. When I asked you whether you wanted postponement of the internship date, you said we did not want.
We did not
apply. Did not want.
We didn't make a representation.
You did not want.
No, I'm not. I would say.
No, wait. If you did not represent, you were willing to write the exam.
No,
that
to be
is,
fair.
some of you whom you stand for,
yes,
were content with the date as it stands.
We didn't have a choice, because when your lordship says content, that means that I would be getting the opportunity to sit for the exam. I wasn't getting the opportunity. When I was given the opportunity on 7th February.
So essentially you were content with the situation as it was.
That is the way of looking.
I was not getting it. I am reconciled to the fact that
that is the way of looking at it. I can't run away from that. That is true.
So that is the way of that 31st March, whatever it was.
Correct.
Very well.
If I didn't represent, then I was keeping quiet about it. I was waiting for my internship.
When did your internship start?
Different dates because of us.
I take it that it was 6 months. 1 year would be over on 11th, which means your internship is a year, isn't it?
May, June, July is when our internships will be getting over for those who are before your
All right. Yes. Otherwise, which means that it started in May or June.
Yes.
So when the advertisement came out, you were just halfway through.
Correct. No. So, Manoj, all I'm saying is, I'm sure there must be arguments as to why the exam should happen on that date. I anticipate that my friends are going to say that, look, admit cards have been issued this morning, 27th morning, and that we have spent a certain amount on the test centers, etc., so don't push the date. I'm looking at it from the other side. I'm saying that.
I'm only trying to ascertain that. Yes. What do you mean by saying that this 60,000 or whatever number are the only people who are concerned? You said. So what is it that you argue? That there are a balanced number of people are there.
Yes.
Those balance are some kind of people who have not made it. So why should we bother?
No. I'm not saying that. I'll just explain. Because 2 lakh odd have registered for this exam. Your lordships on the last occasion have been concerned that many of them had just completed their internships. They were preparing.
No, we never said that. We were concerned that there could be people.
There could be a sizable number.
there are different classes of people.
Correct.
Some of them, many of them may not be fortunate enough to just get in. Many of them may not be fortunate enough to sustain themselves.
That is true.
Right?
No, absolutely.
You have to sustain yourself, so you may work for 2 years.
We were just
then
trying.
start.
No.
So
I'm
there
just
have been
trying
at least,
I'm just trying to assist your lordships. I won't have the exact numbers. I'm just trying to assist your lordships that the classes of people who fall into this 2 lakh odd, there's clearly a sizable number, perhaps a majority, who are not those who have completed or are completing the internship this year. The majority, because the maximum that can be 67,000.
The trend has been, perhaps the pattern has been that those who complete that year may not be, there'll be a sizable number of people, but they will be not the majority in any case.
Correct. But last year, as the lordship saw, they said that we were extending the date so that we can get more people into the pool so that the internships can be completed.
As you noticed, last year the extension of the internship was never that long.
It was only 6 to 8 weeks. That's right. Now,
today,
yes,
there are two things happening. When you, as they say, when you pull the cloth this side, then something happens this side.
Yes.
So how do you balance it? How do we balance?
No, I agree. I know it's not a simple thing that we're asking your lordship. All I'm saying is, like I mentioned last time, that if the counselling is any case going to take place after the 11th of August at the earliest, it may take place even in September or October, knowing how it is. There may be litigations that may drag it out more. Is there much advantage by rushing this exam through at this date when, like last year, even 4 to 6 weeks or 8 weeks, it could be postponed? That's all I'm saying. Is there?
Right.
For everyone. That disadvantage is there for everyone.
Yes, Miss. Who else wants to?
I think Mr.
Tanka is here.
I think also.
He's not there.
No,
sir, he is in code 3 right now on his legs.
No, we can't look there.
No.
The item 43 is holding.
Yes, what is?
Well, would your lordship consider allowing us to give these facts?
See, what he is saying, to some extent, you see, please, first, please look into the, I see, all.
My lords, I have given some dates. First thing your lordships will see that the exam was announced, my lords, 6 months back. On 16th of September 22, the date of this examination was fixed, my lords. The second figure we have, my lords, all this contemplation is not really necessary. Everyone who applied in the first window is 2,03,000. So it's only 5,370 students who have applied in the second window, which was reopened between 9th of February 23 to 12th of February 23. Lordships may now kindly come to point number 2, my lords.
So, according to you, 1,76,000 complete by 31/3, the original date.
Yes, my lords. 27,232 complete by the first extended date, and only 5,370 are falling in the second extended date. My lords, but your lordships will note, my lords, that the date of examination was fixed 6 months back, my lords. Please also note we've given for the last 3 years, but my colleague has already shown that to your lordships. Please see serial number 2, my lords. This is the total number of candidates who have applied. Admit cards have been issued today as scheduled. So admit cards are issued, my lords. Then we have made a chart of the 10 petitioners who are before your lordships, my lords. 17 petitioners who are before your lordships. Your lordships will see that out of these 17, my lords, more than 10 petitioners, 10 petitioners have completed their internships last year or even before that. Lordships may kindly have a look at that chart.
We will not look into that part. We take it's like that, but we'll treat this as more of a class.
But your lordships may still see that it's only 3 petitioners at serial number, kindly have that chart, my lords, which is annexed with this. It's only serial number 11, serial number 13, and serial number 14. These 3 petitioners who fall in that extended period of internship, my lords, who will complete it only in August.
No. I think 14th. Even 15.
No, my lords, 15 will complete by May, so they fall in the first extension. Your lordships will see that the date was extended twice. First, it was extended to 30th June, and then it is extended to 11th of August. Let's kindly also see, we have now a decision on when the counselling will start. Serial number 4, your lordships will see, my lords. The counselling will commence on 15th of July 2023. Approximately 98% of the participating doctors will finish their internship.
Serial number 3.
Serial number 4 of my note, my lords, the status note. Serial number 4. So, my lords, we want to start counselling by 15th of July 2023 without waiting for, my lords, the August date. This will accommodate 98% of the participating doctors. They will finish their internship by the time counselling will begin from 15th of July. Remaining candidates who complete their internships after 15 July will be eligible to participate in the counselling provisionally, and they will be dealt with on a case-to-case basis. Then after that, they will be required to complete the PG tenure of 3 years, etc. My lords. Then preparation, point number 5 is with regard to preparation, my lords. That has already been made. My lords, I already pointed out on Friday, your lordships will appreciate, my lords, that a large number of, my lords, administrative preparations have to be done, which is all in place, my lords. And most importantly, my lords, there is no date available in near future with our technology partner, my lords, to conduct a NEET PG exam, my lords, and your lordships will view this from the point, my lords, that we are trying to put the calendar back into place, my lords, after suffering 2 years with the COVID delays. My lords, this has impact on availability of
Shankar, yes, fine. Yes. On this chart, that serial number 10. Yes, sir. Completed his internship in 2017. That is correct. Right? Yes. You remember on the last occasion you...
And then look at number 7.
2013. No, 2013. Right. Now you submitted that 45,000 would be ready to join you. Yes. Right? Yes. But if you go by the figures at paragraph 1 on page 1. Yes. 2,03,000. Yes. Out of 2,03,000 who had applied, yes. 1,76,000 yes. would be completing their internship by 31. Cannot be right because I showed you that 45 cannot be right. No, I'm saying 1,76,000 completing their internship can't be right because I showed you the annual report which said 67,000.
These are all inferential. This can't be right, can be right. It's for us.
No, I'm sure.
One can.
If they have only 67,000 students, how 1,20,000 can be completing the internship? I don't know. I don't know. I mean, maybe 1 year. Yes. It starts from 2013 onwards.
Yes.
Yes.
So
but you have to take from 2013 onwards.
We have one hard figure, which is 5370.
Yes.
They are the fresh numbers.
Yes.
Beyond that, we don't have. So there is a question of 45,000. That's for sure.
Very good.
So therefore, there's no debate on that.
Right. No, I didn't have this data, Manoj. I only could conjecture.
You have to.
Only they have the data.
You're right.
No, whichever way this goes, I have only one suggestion. They have said that they will start, and this is not with reference to my clients, they have said that they will start their counseling from 15th July.
Yes.
Just logically, it doesn't make sense to start from 15th July if they are going to counsel those who finish on 11th August. After 11th August.
According to their estimation, 98% would be covered by
No, it may. I have no doubt that it will. All I'm saying is that if you do that, suppose the person who finishes on 11th August is the first rank in the entire NEET PG exam, what happens to him?
Nothing. He gets it.
How will he get it? But he won't be part of the counseling.
He is. Please read it.
Yes.
He's provisionally part of the counseling.
Plus, it requires their own rules say that you have to come with the internship completion certificate. If they don't come with it, let them relax that rule. I don't know. This doesn't concern my clients in the East. I'm just saying. If this is what they're planning, then because I don't want another glut of petitions saying you said internship completion certificate. Now you're doing this.
So we'll do the best we can under the circumstances. Not say anything and let things lie as they are. One can understand. You see, it's a very hard decision.
No, it is.
Because there's no adversarial effect.
No, absolutely. So I wouldn't press it further than what I have.
Let's leave it at that. You've done the best that you could.
No, very
Milord, just one last point, Milord. He raised it very well, but I'm re-emphasizing.
Yes.
Milord,
we were all looking at you there.
So I went running to the next.
Yeah.
So what I'm trying to say is, sir, for every candidate who finishes first, second, third, fourth, his subject and college is very important. I mean, they're actually, that's their life. Somebody wants.
No, you're right. Somebody wants.
Now, I don't. I mean, without getting into figures, because we are not authors of figures, and we would not even know the authentic figures today. But the fact is, a lot of candidates will still not have the eligibility to who may be first, second, third, fourth, fifth, to come for their first subject and the first right
Let us understand. I mean,
no, there is a difficulty.
No, not just that. There are too many
pitfalls.
Groups, too many people to contend with, and some of them may have, like you said. I mean, you look at it from one perspective. You've not made it. There is nothing in this world to prevent somebody who has not made it to try again. Or they could take any number of efforts. Maybe even this 2012 person, he may have had his own constraints, he's waiting. Or likewise, on the other side, there are people who have been waiting. That's not to say that they should not have a chance. So who would have prepared? Now,
sir, this became acute because of Neet. First, every state used to have its own exams. Today, this is one date for everybody in India. If you are not accommodated on these days,
right or wrong, all this is a part of the evolutionary process. Sometimes evolution gets it right, sometimes it's wrong. Now you have to take it as it comes.
So what he was actually requesting was not about so much of counselling. It was more to do with the shifting of examination date.
Right. That's the whole claim in this.
If instead of March, if the examination date was April, the people who were selected.
But for the fact that
16
with the lives of people, one could have even said, alright, you are nowhere in the picture.
No, 16 states were not in picture till the last notification.
Nowhere in the picture. Many of you were nowhere in the picture. Haven't gotten into the bus or the train, now you want to get into.
Sir, we are actually what's the student told that was?
See, Mr. Thankar, we understand. A lot of people's they're waiting for this. There's a lot of angst.
Yes, it's their dream, Lord. It's actually their dream to sit for this.
We don't want to belittle it either. So we will not say anything. We will just let it lie, and we're not entertaining. Yes. Having heard counsel, we are appealing.
My Lordship, I'm the aggrieved party from the Telangana State, my Lordship.
You are the aggrieved means you represent the aggrieved party.
My Lordship, I'm representing from the Telangana State, my Lordship, and we are going to impede for this petition, my Lordship.
We are not entertaining the petition. Dismiss.
Grateful, right?
Grateful. Thank you.
Please, one.
I'm appealing for the petition,
Lordship.
Item 8. We're in item 8.
Yes, Lordship. I'm item 8, Lordship.
But the petitioner is seeking bail as he has been charged for the offences under section 376D and 4 and 8 of the Postpone Act, Lordship. Lordship, the petitioner has served more than 3 years.
Come to paragraph 6 of the impugned order.
Please, Lordship. On the other hand, learned counsel for the
second sentence. According to his instruction, the entire examination of the witnesses have been complete, and the judgment is likely to be pronounced within a short span of time. Therefore, the application may be rejected.
Yes, Lordship.
This was 27th of September 2022. What has happened now? Tell us.
Actually, there were 40
We
witnesses.
don't want to hear actually. What have you stated about the stage of the trial?
Lordship, this is the submission of the state.
What you should have said. What is the stage of the trial?
22 witnesses have been examined out of 40.
Where have you stated that?
Lordship,
What is the stage now?
Where have you stated that?
it is at the stage of prosecution witness examination itself. May kindly see page H, Lordship. Page H. Page H.
What is it? See, we are filing this after a year.
Yes, Lordship.
September, now we are in almost
Yes,
March.
Lordship.
So you should have stated the first thing.